If the High Court has, as the High Court has found that there is a freedom, an implied freedom of political speech, surely one day the High Court will find that there is an implied rule of law which applies in Australia.
Interesting. It's an interesting point. I'm very uneasy about anything being implied. Some things, yes, I can agree with that. But the rule of law, I think it doesn't need to be. Its status is more than an implication. It's the basis of the Constitution in this country. So implications, I think their status is probably not as secure as the pre-existing status of the rule of law. Implications are effectively controlled by the judiciary and can be defined, recognised, or simply left to wither on the vine. We've seen that with the very little development that's taken place in the implied freedom for political communication. It's being argued a lot, but rarely, as I'm aware of, of much impact.
When that case that was brought by a former New Zealand Prime Minister against the ABC over freedom of political speech came to the High Court, I persuaded the Press Council, I was chairing the Press Council at the time, to put in an amicus curiae brief. And the High Court allowed us to present that to the full court. We were arguing that this should be a defence. It should remain an individual defence. As you know, they ruled against that and decided that it was a restriction on legislation, on the power to make legislation, rather than as an open defence for everybody. But it was a very interesting experience.
Look, it was, at the time, I remember it quite clearly. I thought a window had opened and we were about to head down the path of the American Bill of Rights, where the American governments are not permitted to make laws that infringe the freedom of communication, freedom of the press, as it was described at the time. And that's where I thought we were going. But subsequent cases closed that window pretty sharply, I'm afraid.
Yes.
The cause of some regret.
Yes. I got the impression that the dissenters and those who wanted to keep it all got together, these are the judges, and they compromised among themselves because it was a unanimous judgment. And I think effectively a deal was done. We will keep this, but we'll keep it just as a restriction on legislators rather than a right for all citizens. But that's the way these things work. But I would have thought that if there's an implication in the Constitution that we have responsible government, that is, governments are formed in the lower house by the government having the confidence of the lower house, and that's not written expressly in the Constitution, but it's presumed because of the financial provisions. Surely, surely the founders obviously assumed that the rule of law would continue, and the whole basis of the Constitution is on the rule of law. Surely, I would have thought.
Yes.
So
look, I agree entirely.
That's what the Rule of Law Institute will have to do in the appropriate case. You'll have to file an amicus curiae, there's a friend of the court brief, to make your position very clear.
Yes, look, I don't rule that out at all. We have considered a number of adventures like that, and I feel sure it's only a matter of time before we choose the right case. We've had discussions with a number of like-minded organisations about how to go about this, and the consensus is that basically you've got to be ruthless. There's so many worthwhile cases out there. You've got to be very, very selective. This is how the American equivalent groups operate. They don't run everything. Nobody can afford, no institution, private institution like ours can afford to run every case that they see has merit. But the way the American equivalent institutes operate is they go over these cases quite carefully and pick one every now and then and go for it. And the record, so they tell me, is pretty good.